Good afternoon. It is my pleasure to welcome you this afternoon for the Fredrikson Lecture in honor of John Byron and to introduce our speaker, Dr. Rebecca Sanderfer. As co-director of the Holleran Center for Ethical Leadership in the Professions, I'm particularly pleased that this lecture honors the late John Byron, as he was a close friend and legal partner of Tom Holleran, our namesake, for many years. John and Tom were cut from the same cloth. Great lawyers who were truly trusted advisors for the many clients they served and were recognized as servant leaders both in their firms and in the community. They remain role models for all of us. It also is a great privilege to welcome Dr. Rebecca Sanderfer as our speaker tonight. Dr. Sandefur grew up in Oklahoma and in Madison, Wisconsin, a Badger. I'm a Badger. It's a good thing. As the daughter of a sociologist, it is perhaps natural that she found her way to sociology as her life's work. But her emphasis on the legal profession and on access to justice was something of a wonderful accident. She started out her Ph.D. program studying inequality and early childhood education. But the professors with whom she was working had a falling out, and so 3 years into her Ph.D. program, she needed to find another research topic for her dissertation, and was fortunate enough to be invited to work with a professor doing research on the legal profession. She has since become perhaps the leading expert on the access to justice riddle that the legal profession and our society have not been able to solve. She founded the American Bar Foundation's Access to Justice Research Initiative, and she is not just a scholar and a teacher, she is a doer. She is actively working to advance access to justice with efforts in Arizona, California, and Utah. She was named a MacArthur Fellow in 2018 for her work on equality and access to justice. So I get to introduce a genius. And frankly, the best kind of genius. A humble genius, someone who knows what she knows, but also appreciates what she does not know. After her prepared remarks, we will have a question and answer session. If you have a question, please write it on the index card on your seat. There should be one underneath your program. And hand it either to Brady or Annie Bokers, who are seated at the table over there. They'll be wandering around. They'll bring them up to Professor Hamilton, who will then hand them to me. Please join me in giving a warm St. Thomas welcome to Dr. Rebecca Sanderfer.
Uh-oh. I'll never figure that out. It's a pleasure to be with you today, and thank you, Jerry, for that very generous introduction. And it's not all that bad being a Badger. Come on. Get a little bit from you there. All right, so I don't know who usually talks to you at these kinds of events, but I'm a sociologist, and I use data, and I often teach undergraduates, so I use PowerPoint because it's a way of keeping everybody on a page, hopefully the one where I want to be. So if this is unfamiliar to you, I apologize, but maybe it'll be fun. So I want to talk about what we know from empirical evidence about access to justice in the United States particularly, but also what we can learn about things that other countries have been trying or are trying now that might inform what we could do here to make our own situation a little bit better. I want to talk first about kind of the access to justice crisis that we have in the United States, and that's an old picture of a bunch of people waiting in a bread line, which is an image that describes our crisis quite well. So we know from my own work, and then if you follow the access to justice news aisles out of Denver put out a report earlier this month on a survey of, I think it's 10,000 Americans and their experience with civil justice problems. And whether you're looking at my study of people in the Midwest or their study of people in the nationally today, what you see is about 2/3 of adults will report a civil justice problem in any period that you give them to report. So if you say go back 4 years, it's 2/3. If you say go back 18 months, it's 2/3. So most Americans at some point in their lives will have at least one of these problems. We know that although every group in the population has civil justice problems, they're not distributed equally. So both in the national survey and in my Midwest survey, people of color are more likely to report civil justice problems than white people. Poor people are more likely to report them than people who are not poor, and women are often more likely to report them than men. One of the things that I think it's difficult to notice if you're working in the justice system, so let's think about these problems. This is, you're working at a wage and hour job and your employer owes you overtime and he's not paying it. Or you're 3 months behind on your rent and so therefore you're at risk of eviction. Or you have a grandchild who you're taking care of and you need to enroll that child in school and you don't have the power to do that without legal documents, for example. The vast majority of those problems will never make it to you. So they'll never make it, they'll never become court cases, they'll never become administrative hearings, they'll never become issues that are taken to lawyers. Where the legal system sits is at the top of a giant iceberg. And that giant iceberg, like all icebergs, is about 80% under the surface. And if you remember that awesome movie, The Titanic, it's not the part you can see that messes you up. It's the part that you can't see that messes you up. So depending on which study you're looking at, it's somewhere between 15% and a quarter of justice problems are making it to some kind of law. So a lawyer sees them at all, or maybe it gets filed as a case, but they get, that person is an unrepresented litigant, right? So one or the other or both. That's about up to a quarter on a really good day. And then everything else is not making it there. Everything else is not within sort of the vision of the justice system as we understand it. That's most of people's justice problems. So there's a double justice gap. There's the justice gap of people who have problems in making it to court and don't have the help they need. And then there's all the people who don't make it to court and have no help in navigating their problems. One of the reasons, when I first started this research, I thought what I suspect many of you think, which is that the reason no one's using law to solve legal problems is because law is really expensive. And in some law is really expensive. Some law is not, however. So you can now, using a computer program or kind of a mass market law firm, get a will for $500. And even if you don't have a big estate, it's a good idea to have a will because it makes things easier for the people who are left behind when you're gone. But most Americans don't have wills, including Americans with large estates that could afford wills. So something else is going on there. And one of the things that I discovered, both in talking with people, just sort of doing focus groups where they describe their issues, but also in surveying them. So someone says, yes, I'm having this specific event. I'm 3 months behind on my rent. Or my child's enrolled in school and the school is not recognized in the IEP. Or my employer's not paying me my full wage. So you say, okay, you tell me you have this concrete problem. What kind of problem is it? Is it a moral problem? Is it a personal problem? Is it a bureaucratic problem? Is it a family problem? Is it a legal problem? And you see something really, really striking. So the most common way that Americans describe their justice problems, their justiciable events. So these are things that raise civil legal issues, have civil legal aspects, have consequences that are enshrined in the civil law. The most common way that Americans will describe them is either as bad luck or part of God's plan. So this is either something that just happens to me because stuff just happens to people, or it's happening to me because it's supposed to happen to me. And if I'm thinking about this as my destiny, or I'm thinking about this as my luck, the way I'm going to act on that is going to be very different than if I understand that problem in a different way. There's another chunk of problems that people think about in ways that suggest they might think someone should get involved in the problem, but it's probably not you. These are problems they sort of think of as our problems. So this is my family's problem, my community's problem, it's a private problem, and maybe I need help to act on it, but that help is going to come from people I already know, people in the circle that make sense to me. It's for less than 10% of justice problems that Americans identify legal aspects of them. That says a lot about why that stuff's not making it to lawyers and not making it to the legal system. So there's a big gap in knowledge and understanding on two sides. people's understanding of the aspects of their problems that may have remedy in the legal system, and our traditional way of providing services understanding that everyone who has a legal problem knows where to go when they have such a situation. So there's a lot of this stuff. It's not understood as legal. It affects everybody. It doesn't affect everybody equally. Its impacts can be really quite powerful. Now, some of those problems are not a big deal, but some of them are a big deal. When you're thinking about these problems concretely, these are all figures that come from pre-COVID because we don't have post-COVID data yet. But some of these things have become legal actions, those 150 million to 250 million justice problems that are popping up in America every year. So before COVID, you had about 3.5 million evictions being filed every year. That's part of that 150 million. You have a whole bunch of people, 4 million pre-COVID, having their wages garnished for some kind of debt. That's another part of that 150 million. And then there's a range of people who are involved in legal actions to try to secure the care and management of adults who are not able to care for themselves. So back before the last time the National Center for State Courts counted, it's about 1.5 million adult guardianship proceedings every year. So those are the things that are making it to some kind of formal legal action, but lots of things aren't, as we saw with the iceberg. So people are facing situations that could end them up in formal legal action or where they might benefit from some kind of legal intervention, but they haven't made it there yet. So again, pre-COVID, you got 7 million people who are essentially defaulting on their student loan payments. I'm sure it's more now. Again, pre-COVID, you had at least 2.5 million grandparents who were raising their grandchildren, which sounds cute, and I would have enjoyed it when I was a child, but my grandparents would have had to figure out how to enroll me in school and how to get me vaccinated and how to connect me to their health insurance, and you can't just do that. It requires a set of legal instruments. As America gets older and then we have more people who are at risk of the different conditions that confront old age. One of those is dementia. So you now have almost 16 million people living with some degree of dementia who have carers. And those carers have to think about how they can balance legally and formally the things that people can do for themselves and the things that people may need some guidance or some outside management for. That's a whole set of legal issues waiting to happen there. We know from the US Census that at least 8 million people are living in housing that HUD describes as substandard. So it doesn't have heat, or it has a major pest infestation, or it doesn't have hot water, or the electricity is not reliable, or something like that. So these are not insignificant problems. And of course, when you have a major shock to the economy, so the 2008 recession, for example, or a global pandemic, that will cause the economy to contract in really powerful ways, and that creates a lot of unemployment. And that unemployment itself can be a justiciable problem because you got to figure out how to attach to your benefits, but then it causes a whole set of other problems. You're now behind on a range of bills because you no longer have an income, because you're no longer employed. So we can only imagine, even setting aside the fact that the eviction moratoria are ending, that various debt collection moratoria are ending, there's this huge backlog of justice problems that will have been created by this most recent shock to our economy and our society. So this is a lot of activity. What we know from the World Justice Project, if you're interested in this kind of research, a couple of years ago did a surveys in about 150 countries that look at what kinds of justice problems people have, how they handle them, and how those problems affect them. And so we have data from that project for the US for 2018, so again, pre-COVID. Working with my colleague, James Tufel, who's a public health guy, we looked at sort of what were the health impacts and the life quality impacts of those kinds of problems. So at least 19.5 million problems in that survey were leading to negative health impacts. So you got sick, or at least you believed you got sick, because you had a justice problem. Or some condition that you already had got worse because you had a justice problem. About 18 million of those problems in that survey led somebody to lose where they lived, or the money that they needed to make a living, or their job. That's going to create a whole set of other problems, some of which are legal and some of which are not. One thing we know about justice problems is many of them emerge in relationships. I mean, if you think about family law, that's about the law of relationships, but they emerge in your relationships with your neighbors and with your employers, and then they can be very stressful, and so many justice problems cause damage to relationships that are the fabric of our lives. And we also know from this study and others that justice problems lead to coping behaviors that are maybe not always the most constructive coping behaviors. So in this particular survey, almost 5 million people with problems self-reported that they were having difficulties with alcohol or drugs as a result of the justice problem or problems that they were having. So a lot of activity, very impactful. We're all at risk of it. What this means is if you're thinking about quality of life measures like disability-free years of life, if we were talking about health, is that people will spend large portions of their lives, if nothing else changes, dealing with and being affected by these problems. So if you're in midlife, so you're 35, 45 years old, you're going to spend, 40, 45% of your life dealing with one or more civil justice problems. That's the prediction based on the distribution of these activities if they don't change, if nothing happens. And if you're a young person, if you're in early adulthood, you're going to spend about a fifth of your remaining life years being affected by one of those negative consequences of a civil justice problem: health, lost employment, damaged relationships, and so on. So very, very impactful, potentially very widespread issues. Historically, the way that we have talked about and thought about access to justice in the United States is as access to legal services. So we think about how can we find more funding for civil legal aid? How can we get lawyers to do more pro bono work? How can we create workshops so one lawyer can help 25 people at one time? That's the way we've thought about this in the past. And I would encourage us to step back from a possible solution and think about the actual problem. And so when we think about how Americans handle justice problems, right now we're in a situation where it almost never involves the law, right? So at most, a quarter of justice problems touch the law. Changing it from 25% to 100% might be undesirable for a whole range of reasons. And one of them is that what we want to achieve here is the substantive outcome of justice, not the process outcome of having access to some kind of expert who might know something about justice. So we can think about access to justice as that just result. So there's a whole set of things that we have made laws about because we think they're so important that the community has a collective stake in how that goes down. So when those norms, because that's what laws represent, when those norms govern how a problem gets resolved, whether the court is involved, whether lawyers are involved, whether people work it out on their own, we kind of want them to work it out on their own, right? We want those just principles to govern life whether or not you hire a lawyer or file a court case. That's access to justice, when the lawful result comes out of the situation. We want to expand that so that more people and more justice problems get that lawful result. And we want to equalize it so that it doesn't matter who you are or where you're from or how much money you have, you are just as likely to get a just result to your justice problems as somebody who is different from you in terms of all those identity markers that we know divide the world that we live in. So we have a double crisis. Access is restricted, so only some people and some problems get lawful resolution, and it's unequal. So some people are more likely to get access to justice than other people, and that's predictable, right? It should be random, but it's not. We can say in advance who's more likely to get it and who's less likely to get it. So now I want to talk about some ways we might solve this problem. And the ways are somewhat non-traditional in the US context, but they're also very traditional in other contexts, and they make more sense if you step back from just providing traditional legal services and think about what the problem is that you're trying to solve. So one way of thinking about how to solve that huge justice gap is to think about it in terms of distributing the ability to resolve the problem more broadly than it is available now. Right now, in most jurisdictions around most problems, there's a thing called the Unauthorized Practice of Law, and it says that, for the most part, only lawyers can do stuff that is the practice of law. Only lawyers can represent you, only lawyers can give legal advice. But even in the context of those rules that reserve the practice of law to lawyers, to a large extent, there are still lots of interesting ways that people around the country are trying to increase people's access to the capacity to act on their problems. One way to think about this is to think about what a lawyer does as a bundle of capabilities, and then you can unbundle it and distribute it to different kinds of things. So what can a lawyer do? Well, a lawyer can represent you. A lawyer can take actions on your behalf. A lawyer can be you, basically, if you give him or her that power. Lawyers can give you legal advice. When you have communications with lawyers, they're protected from disclosure to third parties. So there's a special kind of confidentiality in your relationship with a lawyer. Lawyers can give you legal advice. And then another thing that's really fascinating about lawyers is they are once qualified omnicompetent. So that means once you pass the bar, you can defend someone in a capital murder trial, or do a billion-dollar merger and acquisition, or help them get divorced, or help them set up a small business. You are formally qualified to do all of those things. Obviously, you're not actually qualified to do all those things, but that's the way we've set up that role. So you can imagine taking that lawyer role and breaking it into little pieces and distributing it to people and things that may not be lawyers and letting them do part of that work. So if you look at the examples that actually exist around the country, you get things like New York City court navigators. So some of these folks were social workers, some of them were law students or college student volunteers who got some number of hours of training, I think it was 10. And then they ran around the housing courts in New York City helping people who didn't have lawyers and were involved in evictions. They were available to landlords, but landlords almost always have lawyers, so they don't need navigators. So mostly these are folks who are working with tenants so that they can figure out what are the steps in this process? What is the paperwork that I need to bring? What does it mean when it says go to the Part H? Why would you ever? Every court in New York City is in parts. How does that make sense to anyone? Why would we expect anyone to understand how to navigate that? And so that's what navigators do. They do very basic translation of just arcane, needlessly obscure stuff so that ordinary people can understand them. There are also technological solutions that are moving away from just information towards helping you act on a problem. And one of my favorites is a program called Just Fix. And this is a woman holding up a picture of her phone with a picture of a dead rat on it. And what that particular part of the Just Fix project does is it lets you write a really good complaint letter to your landlord, explaining that that person needs to repair something under city codes. So there's a little guided interview and it says, are there rats? Is there mold? Do the elevators work? Do you have heat? And you answer all those questions and says, okay, you said there was mold, go take a picture of the mold. You said there were rats, go take a picture of the rat. So you do that, that's stage 2. Then you press done, and it writes a beautiful letter to your landlord that says, dear landlord, I'm your tenant at this address. I know that you own this because this is connected to the city's database of who owns what. And by the way, you're currently in violation of the following codes. And if you don't believe me, here are the date stamped, time stamped, geolocation stamped photos from my phone documenting that this is your premise, and this stuff is messed up. Great way to turbo-taxify, sometimes they say, something that would be very difficult maybe for someone to do without that assistance. A number of states have created, sometimes I call them junior varsity lawyers, and the reason I do that is not because they don't know how to do things very well, but because they're not allowed to play in the big leagues. So they have some kind of limited certification. It's usually only one or a few areas of law, so only family law or only family and landlord tenant, and they can usually only do some things. So far, none of them can appear. They can help you fill out documents and file them, but they can't make arguments in front of judges or even to the other side usually. So there are a range of states that are exploring that, creating sort of pieces of lawyers that could be a career for someone. And then every state in the country has a statewide legal aid website. So that's yours. And you can go there, and all of them provide information. Some of it is really accessible. Some states are not so accessible. Some of them provide programs that will help you fill out a form that you can then file with the court, say if you need to file an answer to an eviction or file an answer to a debt claim. So there are a range of ways that people are trying to do this stuff within the context of the existing rules. And some of these things work well, and some of them don't. And for some of them, the existing rules are good enough, and for some of them, the existing rules are too limiting. Let's think about digital tools. So JustFix is one of, I locked some undergraduates in a windowless room, which is one of my major research methodologies, and I made them look up all of the tools they could find on the internet that were working in any US jurisdiction, and we found 338, I think. And then when they were still locked in the room, I had them code those things for what does it do? Does it give you information? Does it help you diagnose a problem? Does it create a form, etc.? What you see is that what people need if they don't understand that their justice problems are legal is someone to help them understand that their justice problems are legal, and not very many of these tools do that for reasons that if you know about unauthorized practice of law rules will kind of become clear to you. Most of them just give you information or connect you to lawyers. So they connect you to that traditional idea of what access to justice is. Some of them make documents. Some of them, like that JustFix program, help you collect and organize evidence. I mean, that's what that is. Here's the letter and here's the evidence to back it up. So a few of them are useful, but most of them are just big piles of facts, usually written in turgid prose by people who mean well, but have not spent a lot of time thinking about how an ordinary person might want to access this information. The other thing about digital tools as a way of providing access to justice, the thing that's awesome about them is they're like infinitely replicable. Like once you write the software, you press the button 10,000 times, you have 10,000 free copies, right? It's really cheap to distribute. But many people who can't use current legal services can't use these tools either. Only a quarter of them are available in any language other than English. Now, this is a country with an enormously diverse population, an enormous number of people who don't speak English well enough to use the language of the courts, which is English, or to interact with these tools, which are all in English. So that's an issue. Another issue is that 1 in 6 Americans adult Americans can't actually read functionally well enough to be in the 3rd grade, essentially. So we have an illiteracy problem in the US. And then, of course, if you can't see text, you can't read it, whatever your literacy level may be. So only about 16% of these tools are usable by people who can't use a text-heavy interface. So that's a challenge as well. So yes, this is a door for some folks, but for many folks, it's just another closed door, like what they confront now. The other thing you see when you look at not the technologies, but the humans, so the humans that are able to sort of walk with you through a process and help you figure out what the next steps are and organize your paperwork, is that sometimes they can do exactly what someone needs. So among the New York City court navigators was a kind of super navigator who was a social worker who had received, I think, 15 hours of training in how to work with people who were involved in these eviction cases in the Brooklyn housing courts. And it was only unrepresented litigants facing eviction. It was basically the same population that legal aid serves, making the same kinds of case selections. So legal aid doesn't serve everybody who comes in. Nobody serves everybody who comes in. Legal aid thinks about who can we help the most. So people who have disabilities that are going to make it extra hard for them to navigate this on their own, people who don't speak English and so will have extra difficulty navigating this on their own, and people who are at serious risk because they have serious rent arrears. So this is the same kind of population of clients that legal aid is working with. And the navigators would go with them. They were navigators for the whole case. So you came in, they did intake, they figured out you were eligible, and they're like, okay, here's your navigator. And that person went with you to every appearance that you had in court, went with you to every meeting you had with the landlord's attorney, which is where a lot of the action happens in eviction cases. And under the New York State court rules, the navigator couldn't advocate, couldn't say, make a legal argument, but they could answer questions directed to them by judicial staff. So the judge could say, hey, does Mrs. So-and-so have a receipt for the rent? And Mrs. So-and-so could be totally flustered and confused and stressed out, and the navigator could reach into the plastic bag of receipts and say, yes, she does, it's right here, right? So to get the information that the court needs to do its part of the system. But the other thing that the navigators did was they used their mad social work skills. The reason most people are under an action of eviction is for a claim of unpaid rent. And if you're talking about people who are poor, the basic definition of poverty is not having enough money to meet basic expenses, and so the problem is often being able to pay the rent. So the navigators would, outside of court, work with these same clients to connect them to rent subsidies that they might be available for or eligible for, to veterans benefits that they might be eligible for, to family counseling. Like, let's say you have an elderly couple with an adult child living at home, and the adult child has a job but isn't contributing to the rent. So they connect them with family counseling and be like, we're all in this together. We all need to contribute to the rent, right? So working the legal angle, but also the human and social services angle. And what you found is that at a pilot scale, they had a 100% success rate. That is, not a single person assisted by these navigators was required to leave their apartment. There were no evictions among their client base, selecting people in the same way that legal aid selects people. And they cost about half of what a legal aid lawyer costs. So they're running at about $1,500, $1,800 a case. And legal aid at that time was running about $3,200 a case. So it is possible to identify situations where there are more effective and less expensive interventions that don't involve lawyers, even without changing any of the rules about who can appear in the unauthorized practice of law. But why not go a little bit farther? So I think we often feel like whatever rules we operate under wherever we are eternal and were given to us by some massive force, but in fact we made them up, right? What the definition of the practice of law is and what the rules of civil procedure are, we made them up, which means we can change them. And there are some reasons to think about changing them, particularly if you're thinking about access to justice. There's two kinds of long-standing rules that feel eternal but are about 100 years old. So one is, if you haven't had to take this class yet, you will someday, Rule 5.4, which more or less says only lawyers can make money off the practice of law. Only lawyers can own organizations that produce legal services. And the other is that the practice of law is what lawyers do, and if lawyers do it, no one else had better be doing it. Again, these are things that we can change, and they feel eternal, but they're only about 100 and 120 years old. So what's happening to kind of explore the capacity to make these non-lawyer solutions a little bit more effective? Well, one is we're thinking about ways to have different kinds of providers to provide these services, and they might be human beings, or they might be computers. So that Just Fix program, which is already pretty awesome, could actually move to giving you legal advice, perhaps. Or there could be a person who works with you with that program who can give you legal advice around how to handle your landlord. We're thinking about new kinds of organizational structures. So could non-lawyers own law firms? Could you have outside investment in law firms? The theory around access to justice would be that would allow them to capitalize and they could go to scale. So part of the reason, if I do an individual bespoke artisanal service for each person who comes to me, I'm doing the same thing over and over again in a new way instead of commoditizing it somehow. So one of the theories is that if we allowed that kind of investment, we would find ways to go to scale and reduce cost. Those changes in Rule 5.4 can allow multidisciplinary practice. So if you think back to that eviction example, there's a lot of things going on that are leading to the situation where the person is not paying their rent often. So we need to work, if the problem we want to solve is homelessness or eviction, we got to work all around that whole thing. So changing that rule allows new kinds of collaborations between different kinds of providers. And then the other thing we know is that it's much better to meet people where they are when they have justice problems. Well, they go to grocery stores, and they go to department stores, and they go to malls. Why can't we place legal services there? The UK already does this. They have a big grocery store chain called Tesco, and they have Tesco law. So you go in, and between the nail salon and the eye place is the law office. And you're already there, so now you can get access to those folks. And then finally, there are explorations of fee sharing with other professions. So for example, this would be the ambulance chaser example would be, I'm a chiropractor, you come in, you've been injured, I say, you know what, it's terrible that this happened to you, you probably could get some compensation for this, and I hand you the lawyer's card, and then the lawyer pays me a fee. That would be pretty much at the edge of what I think the American legal profession could tolerate, but you can imagine other kinds of models that are basically about revenue sharing in ways that, if the access to justice goal would be, it makes it easier for people to connect their problem to law and to someone who can act on that problem. So these are the kinds of things that jurisdictions around the US are exploring. The jurisdiction that's farthest along is Utah, and the model that it has taken is what it calls a regulatory sandbox. So this is a term from tech. And the idea is you create a space and then people play around in the space and do experimental things. The thing about Utah's sandbox is it's evidence-based. So you apply to be admitted to the space and then you're monitored because the question is, does this work? If we're going to release these rules, we want to know that it has the results we want and not some unfortunate, really bad impacts. Once you're admitted, you get this little stamp. You are an OLSI regulated entity, and that's going to allow you to have non-lawyer ownership, perhaps. It's going to allow you to have non-lawyer service provision, perhaps. It's going to allow you to combine those things, depending on what you've been approved to do. It's evidence-based regulation. So the way we regulate the practice of law now is we create a whole bunch of upfront rules. You gotta pass the bar, you gotta go to law school, you gotta buy a bunch of insurance, you gotta pass character and fitness tests, and we have no evidence that those have any effect on the actual practice that comes out on the other side. It's the traditional way that we've done it. So this model says, well, let's see what actually shapes people's behavior, and let's focus on the actual behavior we want to shape, which is not, did you go to college for 7 years? It's, do you behave ethically? Do you provide competent services? Let's measure that and see if that happens. So Utah focuses on 3 harms. It's focused entirely on consumer protection. Did you get the wrong or inappropriate legal result? So you go to the person who's not a lawyer or the law firm that's owned by Walmart, and you get a legal error. Did you get terrible advice? So they didn't tell you about an important filing deadline, or they didn't tell you that you actually had a right of action, either because they were negligent, or they were incompetent, or they just didn't care, or did they mess up that way? And then finally, did you buy something you don't need? Did they sell you something and not provide it, or did they upsell you to something that's completely unnecessary given your situation? That's the harm you're trying to prevent with the regulation of legal services. So why not measure that harm? That's the logic of this model. So when entities apply to enter into this experimental space, we assess their risk level. And since no one has ever done this before, we have to come up with a rule of thumb, and the rule of thumb is the more you depart from the traditional practice of law, the riskier you are. So the more non-lawyer ownership there is, the more non-lawyer participation in the practice of law, the riskier you get, low, moderate, or high. And then you're monitored, and how much information and how frequently you have to give it depends on that risk level. So a low-risk entity, every quarter, a little bit of information. A moderate or high-risk entity, every month, a lot of information, including subjecting a random sample of your work product to an audit by lawyers to make sure that you're not making legal errors, giving people terrible advice, or making them buy things they don't need. Okay, why would we try? I know to some of you this sounds nuts. To some of you it sounds okay. But why would we try this? Well, there's a range of reasons. So one is that we can manifestly say with 100% confidence what we are doing now is not working. So for 60 years, we've tried to solve this problem by having some amount of federal investment in civil legal aid and getting lawyers to do pro bono and getting other kinds of donations, and it's a resounding failure. That gap, that gigantic gap, is still there. And at this moment in history, it's probably a little bit bigger. So that says, at least try something different. The second reason to change is to think about what consumers want and need. And the best people who can tell you what consumers want and need is consumers. One thing we know is that these kinds of ways of delivering legal services exist in some places in the United States already, and they've existed in other countries for a long time, and so we can look to see if people want to use them. One thing we know is that people are often not looking for someone to take over their problem. They're often looking for someone to explain to them the kind of problem that they have and what they can do about it so they can make an autonomous, informed decision. When there are people who are not lawyers available to help Americans, they're actually quite happy to use the services of those people. And the other thing that's really interesting, if you're thinking about that iceberg and getting people who should be taking action to act, the more entry points you provide to action, the more likely people are to act. So our system of sort of everything or nothing encourages people to do nothing in a way that a system that has more entry points encourages people to take action. So one way to think about what people are looking for is just to ask them. So we talked about those statewide legal aid websites. So those are people who already know they have a legal problem, and they're hanging out at the legal information source looking for legal information. In many of those websites, there's a live chat where there's a human being on the other side and you can ask them questions. Sometimes it's a law student, sometimes it's a lawyer, but then that person can answer your questions without practicing law, right? They can give legal information, they can tell you where on the website to go, but they can't say, oh, it sounds like you've got this kind of problem, because that would be crossing that line. They're not your client, even if you're a lawyer. So, still locking undergraduates in rooms. Don't you want to come work with me? Doesn't it sound great? I have a set of windowless rooms filled with undergraduates. I had them code for a rural state and an urban state, these legal aid live chats. What are people asking for when they type in their questions? Are they asking for a lawyer, or are they asking for legal advice, essentially? And there are differences depending on where you are and the kinds of problems people are coming to the website with, but typically what they want is advice. They don't want a person. They want to know what's going on and then make their decision from there. Another way to find out what people are looking for is to go back to those surveys where people have not necessarily figured out it's a legal issue, but they may have gone for help with the wage theft problem or the potential eviction problem or the child's IEP problem. So they've sought out help. The most common place that people seek help is actually their friends and family. And then the second most common place is everywhere else. And that includes lawyers, but it also includes religious organizations and community organizations and city offices and unions if you're in a union and professional organizations if you have one of those. So people are reaching really widely for assistance. So if you say to people, okay, so you went to somebody for help, what did you want when you went? Again, the most common thing people want is advice. What kind of situation is this? What can I do about it? What are the pros and cons of different courses of action? Sometimes they want someone to take it over for them. Sometimes they want someone to send them to the right place. But the most common thing that they want is advice, and that's true whether they're going to friends and family or whether they're going to those more formal sources like a city agency or the government or a lawyer. So this is what people want. So why wouldn't we start there in offering and designing services around them and their needs? In this country, in a range of federal tribunals, in a range of state tax courts, in immigration courts, people who are not lawyers can represent people who are involved in different kinds of proceedings. And this has been true for at least 60 years across these range of proceedings. This is research from a study by Bert Kritzer, who I think is emeritus at the University of Minnesota Law School now. But across the settings in which he studied, about a fifth of the representatives, when people have representatives, about a fifth of them aren't lawyers, which shows us that at least a fifth of the time, people who are seeking representation are willing to work with these folks and often to pay them. The other thing you see if you start to look cross-nationally, there are countries that organize access to justice in different ways. And the more entry points you make, as I said a moment ago, the easier it is for people to get in. So we can imagine two different contexts. So one would have a very small legal aid system that's not enough to serve a very small part of the population, and it would have really strong UPL rules. So only lawyers could provide legal services, not much else available out there. So you could imagine comparing that to a different kind of really existing context where you've got expansive legal aid. And in this particular context, that was something called Judicare. So it's just like Medicare. You get a voucher from the government to pay a private attorney to deal with your justice problem. At the time when I did this study, that was available in full or partial subsidy to 60% of the population. So very wide subsidy of the purchase of services from lawyers. But at the same time, this was a jurisdiction where there are no restrictions on giving legal advice. So anybody can give legal advice and can charge for it. And there's a developed advice sector where that's what people do. Sometimes it's general advice that's offered by neighborhoods. Sometimes it's advice for particular populations, for the elderly or for young people. But there are all these folks out there whose job it is to give you legal advice. Well, it may not surprise you that that first jurisdiction is the United States, right? Very limited legal aid. Only a few people in the population are eligible for it, and there isn't enough to serve those people at all. What you see there is that the most common way people handle their justice problems is by trying to handle it on their own, what's called their self-help. About a quarter of the time they go to law. About a quarter of the time, they do nothing at all. These are problems around money and housing. So these are not insignificant problems. These are you could be homeless or destitute kinds of problems. And only 8% of the time do they take these problems to non-lawyer routes. Well, why would they? Because the non-lawyer route can't do anything for them anyways. Well, so let's compare this to the other jurisdiction, which happens to be England and Wales before their major, they did a major legal aid reform in 2008. This is before that. So you got 60% of the population eligible for free or heavily subsidized services from fully qualified lawyers, okay? Lawyers are free. At the same time, you have lots and lots of services available for people who aren't lawyers who can actually do stuff, who can give you legal advice. So in this context, you see the same pattern. The most common way people handle their justice problems is by just trying to work them out on their own. But almost nobody does nothing. Only 5% of folks in that survey, when there are many options, do nothing. People are much more likely to do something. But even when law is free, they are more likely to go to these non-legal sources of advice because those are legitimate, valuable, effective routes to their understanding of how to solve their own problem. So opening this up is a way of dealing with that exclusive issue we were talking about earlier, that access to justice is restricted and unequal. This is a way of making it less restricted and less unequal. There's a third reason that we might try this, and this is the kind of reasoning that led the Utah Sandbox to test its experiment. And that is, in jurisdictions where people who aren't lawyers can provide legal services, the research is really clear that when the non-lawyers are specialized and they learn how to do one or two things and they do them well, they can perform as well or better than attorneys, even when you have attorneys grade their work. So the marquee study for this was done as the country was preparing for this big legal aid reform. And what it did was compare the work of non-lawyer service providers of different types to the work of solicitors, so office lawyers at that point in the UK. And what you find, and the way you did it was you had banks of lawyers who were specialized in those areas who audited the work product, a random selection of case files from both the solicitor firms and the non-lawyer firms. And you see that everybody makes mistakes. So below threshold competence, that's a failing grade. Like whatever work this provider did for this person, it is not good enough. That's about a quarter in both instances. So lawyers are making significant material errors a quarter of the time. And non-lawyers are making significant material errors a quarter of the time. Everybody screws up. That's just the way it is, apparently. But that also means that they're not screwing up 3/4 of the time. 3/4 of the time, both the lawyers and the non-lawyers can do this well. One thing that was very striking in this study that you see in other contexts is that, yeah, both of them can do it well, but who can do it better? So the non-lawyers were 8 times more likely to have their work rated as excellent than the lawyers were. And it's not because non-lawyers are better people or nicer or faster, but because they specialized in this thing and they got very good at it. So there's a specialization that allows people who may not have full legal training to be really, really good at what they do. And that's an opportunity that we could pursue here as well. This work can be done well by people who are not lawyers. What I hope this invites you to do is to think about possibilities. So I've talked about a lot of evidence, and it's an evidence base that it's grown pretty dramatically over the past 15 years, and we're at a point where it's going to grow more. We're not flying blind. We're not wondering about how this stuff works. There are many, many questions that we still have, but we really have some amazing opportunities here to use knowledge that we've accrued to design a better world for ourselves and our neighbors. And so I hope that this has invited you to think about ways that we might do that, and I look forward to our conversation. Thank you.
Thank you. So this is the question and answer portion. So if you've written questions down on index cards, please hand them to Annie or Brady, who will bring them up to Neil, who will kind of sort through them and bring them up to me. While we're doing that, let me start with one quick question. You shared information on the Navigators program in New York, and you shared a little bit on cost savings that a navigator's case, I think, was $1,500 to $1,800 compared to legal aid dealing with those similar cases being $3,200. How is the navigator's system funded?
The navigator's system was funded by philanthropy. So it came out of housing rights or housing advocacy organizations that get money from different kinds of philanthropic foundations in New York City. Because legal aid doesn't want to share.
So related to that then, is anybody studying how to generate more philanthropy for these types of creative legal service options?
So that's a great question. When Utah started its Sandbox, the dream of people like me was, wouldn't it be exciting if nonprofits moved into this space and took advantage of this opportunity to design new services? A great example would be domestic violence advocates. So the Violence Against Women's Act, there are domestic violence advocates all around the country, and the really good ones are, let's all be frank, already giving legal advice. That's what they do. And so this would allow them to come into the open and perhaps have new sources of funding. The thing we found in Utah was nonprofits are so stretched just doing what they do now that saying to them, hey, wouldn't you like to design a completely new service model and train a bunch of people to do this in a different way? Doesn't that sound fun? They balked at that. And so we got philanthropic money to sort of coach them and help them design these services and find funding for them. There is that. There are also social impact bond models of doing this in different kinds of places where you get investors to come in and fund the cool thing, and the goal is that maybe they'll make a little bit of money, but the bigger return is the social return on what you do. And I'm very reassured that he's like policing these questions.
The first two weren't bad. If access to lawyers is not the solution to the access to justice problem, what role for lawyers do you see in being part of the solution?
That's a great question. So access to lawyers is obviously essential sometimes, right? I mean, those of you who are law students are learning really important things that lots of other people are not going to know, and those are skills that they need. So lawyers will never be obsolete. Don't worry about that. But I think lawyers can be part of the solution. Lawyers love rules. This is what I've learned from hanging out with you people. And I think one thing you might thinking, those of you who really love rules, sort of how could we design better rules, right? If the goal is let's open up access to justice, how would we regulate differently? And so Utah as an experiment, it may be a complete failure, right? But there are other things that we could try. What are some things that we could try? I think another thing lawyers could do, there are 1.4 or 6 million in the country, a lot. So that's a big group that could be organizing around how to solve these problems. Regulatory reform is one tool. More funding for legal aid is another tool. Designing services in different ways so that they're around people's problems and not around our professional silos is another tool. And lawyers could be thinking about how to form the relationships either among themselves or with other groups to do that more effectively. Because y'all are pretty smart.
So that raises another question, or I think segues into another question. What are the prime obstacles to your new models, and how should they be overcome? For example, protectionism or other reasons, right? So you just said we have 1.4 million to 1.8 million lawyers. Could they organize they're bright people, they've got great training. Part of that training is to be problem solvers. These are big systemic problems. Can't they organize themselves to solve these problems? Isn't one of the challenges, and Washington, maybe you could tell them a little bit about Washington. Washington would be an example of this. Protectionism is a big hurdle. Lawyers, in many respects, don't want to solve these problems. Maybe that's a bold statement, but would that be a fair statement?
I might put it differently. I would say if you're going to have a monopoly, you better make good on it. Right? You can't have a monopoly where you only serve 20% of the people who could be using what you control. So in Washington, they created one of those certificated paralegal, independent paralegal programs called a limited license legal technician. And it could do a lot vertically in family, but it could never represent you, either in court or like to your soon-to-be ex-spouse. There was a lot of opposition to the creation of that program, and it was, I would say, killed, but they say sunset this year, and it never made more than 25 people who can still practice this thing. And a lot of that was the opposition of the bar. In Utah, we have tremendous opposition from the bar. In California, where I'm also working on these issues, there are pockets of opposition from the bar. And I think there are a range of sources of these. I was talking to a Supreme Court Justice the other day who said, does this mean my law degree is worthless? Like, if someone else can do this, does this mean I did all this hard work and went through all of this stress and suffering for nothing? And of course, the answer to that is no. You know, this is somebody helping someone fill out the paperwork to get a temporary order of protection, and you're deciding constitutional cases. Those are pretty different, right? Your expertise is not undermined by this, but I think thinking about that concern that people have is an important one. I think the answer to the protectionism argument is twofold. So one is lawyers are not serving these people anyway, right? They're not running around going below the surface, poking in the iceberg, trying to find what's there that they can help with. They're not. So it seems unlikely that, given that that's the case, that this is going to take work away from lawyers. But the other thing to think about is that these new models are opportunities for lawyers too. So one thing that we saw in Washington State was, so you have these super paralegals who can practice independently, and several law firms figured out, wait, this is a great opportunity for us because we can do two things. These people charge half, a third of what we charge. So that's a whole market segment that can't use any of our services right now. Let's hire these people into our law firms, penetrate this new market, and then when they can't represent people in court, so when their clients need representation, they'll unbundle that off to us. And so now we have, our pie got bigger instead of smaller. And so I think thinking about those elements is an important part of meeting resistance, which is, I mean, it's totally understandable.
Is there, so that's a helpful answer on the protectionism piece. And so part of what I'm hearing you say to us and to our students is don't be protectionist, right? Think creatively about solving these problems. But is a separate hurdle just figuring out what an affordable price point is, both for the people who need a service and for those who have some training, let's not say it has to be lawyers right now, to provide that service, because they still have to make some money. So are there models that have kind of solved that riddle and figured out what a functional price point is?
Your friends Rocket Lawyer and LegalZoom have figured out how to do that for small businesses and for people who need certain kinds of paperwork and limited legal advice, because they have, oh my gosh, it's tens of millions of subscribers. So obviously that's a problem that can be solved. But I would say it's solved by, lawyers are not unique in this particular way, but there's something about trying to understand everything yourself that doesn't make any sense, right? So when I went to get a will, I actually didn't try to write my own will. I paid a lawyer to write my will because they know about law. And in the same way, there are enormous numbers of marketing firms and services that could help lawyers design business models. And I think they take less advantage of that than they could.
So that's an area where we aren't sufficiently creative in thinking about how to price our services. One question about the UK, and then I'll come back with a couple more on our system. And could you maybe explain what the change in the law was in the UK? Did they get rid of some of this, or did they expand this, what you described in England and Wales, some of those services?
So just to step back a little bit and talk about the history of legal aid in England and Wales, the regime that was operative in the graph started right after World War II. And it was part of the welfare state that they created after World War II. And I'm going to be completely honest with you. Lots of people made precipitous marriages at the beginning of the war. And the government looked around at the legal aid system and thought, oh my God, we're going to have to spend millions of dollars getting all these GIs divorced. And so they said, is there an easier way to do this? And so they started funding advice services that could help people do a lot of it without. So that's where the Citizens Advice Bureaus came from, was the sort of recognition there was going to be this huge legal need. The Judicare system, just like a Medicare system, is demand-led. So if I'm going to get a voucher anytime I have a problem, any eligible problem, the citizenry, am going to make it more and more expensive over time. And so when the conservative governments came in, they said, we've got to find a way to make this legal aid system cheaper. So they restricted dramatically the kinds of problems that you can use that Judicare system for. And they tried to expand technology and these advice services. It's not clear. The most disadvantaged people obviously lost out there. Middle-class people are doing okay, they think.
All right. So this unbundling, right? You were just talking about this. The Washington firm brings the paralegal, the LLLT in. That person is more affordable. They do what they do. But when you have a complex case, it gets kicked to the lawyer. So the question is, haven't the physicians already crossed this bridge with all the different types of medical providers? And why can't we learn from them on that?
This is a great question that people often bring up, and I like to remind them that 50 years ago, to have a blood draw, there was no such thing as a phlebotomist. There was an MD, right? And imagine if you were a surgeon, and instead of being all really proud that you did the cardiothoracic surgery and then lifted your hands up and walked away, you're like, I'd really like to scrub this guy down and shave him and then stitch him back up, because that's really what it's like to be a medical professional. Law has a lot of opportunities to divide things up in that way so that people with really extensive training do the cool and interesting and complex part, and then other people can do the also very important parts, but that may not require that kind of training. I think one of the pressures that you see in the medical world that you don't see in the legal world is insurance. So if I'm an insurer, I don't want to pay a physician to draw blood. I want to pay a phlebotomist with a degree from a community college to draw blood. You don't have that pressure in the legal world. And I think that's one of the the creative thing you all need to think of is what would be the external pressure that would push law to do that.
So just on that point, I didn't read the story. I saw the headline. There was a headline online yesterday. Employers increasingly look to legal services plans. Is that a doorway to this insurance pressure, or is that something different?
So I didn't read the story either. I'm just like you. But there have been different efforts in the U.S. to get people to buy legal insurance, and they've basically failed. Very few Americans have it. It's hard to finance it in a way. I mean, if you compare Germany, like lots of people have legal insurance. It's very hard to finance it in a way that it would pay for the places where people really need it. So you don't really, where you really need it, maybe you need it to look at a contract. That's easy to insure. But where you're really going to run into big expenses if you have a contracted, contested divorce. That's $25,000, $125,000. People are bankrupted by that, and you can't have an insurance system. They haven't found a way to make a functional insurance system around those spectacular costs.
So if they wanted to solve that riddle, that would be really good.
Oh, yeah.
Okay.
I'd invest my retirement in your legal insurance fund.
Great. So 2 training questions for you. What type of training education would you recommend for the non-lawyer specialists? So if I heard you correctly, what Washington required, partly because of protectionism, was a pretty high bar of training. So what's enough? What would be an efficient and functional amount of training for some of the other service providers?
I would like to thank whoever asked that question. if you look at what state Supreme Courts and legal regulators are open to, they're open to those certificated professionals because it's a model that makes sense to them, right? So you go to school for a certain period of time and you take some exams and you buy some insurance and then you look like a lawyer and so it makes sense. All these upfront restrictions. It's pretty clear that if you're focused on one particular kind of problem, you could get by with 40 hours. Domestic violence advocates certainly don't get 4.5 years of training and pass bars, but they do their work really well. So I think there are lots of opportunities to make this simpler, but it has to be pretty focused. It can't be this idea that you have sort of a generalist the way we do with law. It's got to be, you know how to do these things, and you learn how to do those things.
And right now, if I'm remembering your slide correctly, those things are domestic violence, Social Security disability, immigration, individualized education plans?
Eviction.
Wage
theft.
So there are a half dozen, maybe a few more in various states where this is happening. It's just not happening widely enough.
Yeah.
Okay. So for our law students out there, what specific steps could a law student take to address the systemic challenges you see in access to justice, or to prepare themselves to maybe take steps to address some of those systemic challenges?
I think most lawyers will actually end up specializing in stuff, even though we don't allow you yet to say that you do. So when you're thinking about the kind of legal work that you want to do, who are the other groups of people who are working on that problem, whatever it is? Maybe it's capitalization of transnational firms, or maybe it's eviction defense. But whatever that is, who else is working on that, and can you learn from them about their perspective? Are there ways that you can learn from the clients you might serve about their perspective, so that you would have a sense of the problem that you're trying to solve as the way it exists in the world, not necessarily just the way it exists in the law? I think another thing you might think about is, do you want to start working on this now, right? So there are groups out there that are working on wage justice, that are working on housing justice, and they aren't necessarily fronted by lawyers. So if there are activities around the issues that are important to you, immigration, whatever it might be, are there ways you can get involved in that now and start to see how a coalition of different kinds of experts or different kinds of actors could more effectively solve these problems than the way we do it now?
So you mentioned technology a couple times, the Just Fix program, which is New York, or how far do you believe purely technological means can go to provide good solutions? Is the tremendous advance in technology a real opportunity to do more for people who don't presently have access?
At this point, it's a real opportunity to do more for people who don't presently have access if there's kind of a decision tree to solve their problem. If you can imagine the possible permutations in advance and sort of lay out choice points, I think it could be very helpful, particularly if you don't expect that everybody's going to find that and use it on their own, but that it might be mediated by human beings. So it might be mediated by community organizations or by faith organizations or something like that. So you're putting the technology in the hands of somebody who's right on the front lines, and increasing their capacity to be helpful and to help people take action on their own problems. I mean, right now, come on, Siri can't understand little children asking for cookies, right? I mean, there's some big technological advances we need to make that would allow these things to be smart in the way we imagine, like robots from the Jetsons being smart. I think another thing to be realistic about is access to the hardware and the capability to interface with those interfaces. So if you're cell phone dependent, you don't have the data plan that allows you to do this. The program may not be designed so that you can use it. And you may not be comfortable interacting with some bizarre computer program that's trying to help you with a problem. So I think another thing about these technological solutions is they're always going to require people They're always going to require some kind of human. It's like when you check in yourself at the airline with that little kiosk. There's always somebody floating around, so when you freak out and think that you've accidentally canceled your flight, they can sort of get you back on the right track. And that's going to be true for lots of these issues as well, because it's not just that people have problems, they're often like in extremis. And they need some like backup reassurance, a little bit of advice, and a computer can't yet offer that to you.
I'm thinking about my recalculating GPS system, right? Always recalculating. But even not just airlines, right? Grocery stores. Mm-hmm. If you're doing the self-checkout at Cub or Target, there's always a helper there for when where it says, please check whatever. All right, do you see, I think you talked about this a little bit, you have some data that speaks to it, but do you see a danger for clients in receiving legal advice from someone without a complete legal education? Or maybe phrased differently, how knowledge is dependent solely on years of experience, but not everyone has that. So one of the things we talk about when we talk with students about the legal profession, it's a legal profession because clients rarely are well situated to know whether the lawyer is doing a good job. Are they any better situated to know whether this other legal service provider is doing a good job? So think about the Wales and England data on solicitors and others. Maybe a different way of asking that is, are you confident those clients really knew? Oh, those weren't clients, those were attorneys. Okay. So how would we know that clients really were well served by whoever their service provider is?
That's why I like evidence-based regulation. So you can actually assess work product or look at complaints or look at errors, and you can know whether the way that you're trying to protect people is actually protecting them or not protecting them.
So how is Utah doing that, for example?
So Utah does it by, if you're admitted into the Sandbox, you have to report information on who you served, what you gave them, how much you charged for it, what the legal result was. And then if you're higher risk, you have to submit your work product to regular audits, and then we're working on secret shoppers.
Okay, so right now there's not any data from customers or clients about their experience with those services.
There are complaints. So either complaints that every entity is required to report any complaints they receive from their own clients, and then complaints can also be reported directly to the office. And with 2,000 instances of service, we've had 3. And my favorite was, I told Jerry about this earlier, it was a lawyer complaining about another lawyer in one of these ABS firms. And the complaint was the lawyer who was complaining wanted to settle, and the other lawyer insisted on taking it to trial. What a jerk. So, what actually, it's very early in the experiment, but there's no evidence yet of any kind of significant harm. Now, to your point about do clients know? Clients know if you return their calls. Clients know if you're respectful. Clients don't know if you've made material legal errors. And that's true for attorneys, and it's true for plumbers, and it's true for limited license legal technicians. And that's why you want some kind of regulation, because it's what economists call a credence good. I have to trust you not just to provide me the service, but to tell me the service that I need. And so you need some way to sort of keep people ethical and competent in that kind of context.
Okay. I've heard that lawyers are disappearing. Do you think this is true? Is there any evidence that this is the case? Do you think that these non-lawyer service providers will eventually result in lawyers disappearing?
So when I first started studying American lawyers, there were less than 1 million of them, and now there are, I think, 1.6 million of them. So you're not shrinking. The more on-point evidence actually comes from the UK. So the UK has had non-lawyer advisors forever, but they did make a big change. They allowed non-lawyer ownership. And one of the concerns was then law firms would be driven out of business. But since they've allowed outside investment in legal services producing organizations, 2 things have happened to the UK legal profession. It's grown, and its income has increased. So there isn't yet any evidence that per se is gonna push lawyers out.
And if we look at the medicine model, we haven't lost doctors by having phlebotomists and nurse practitioners and whatever else. It's just that they get to do the specialized thing they like to do. And so this might actually, your example of the Washington firm, this might actually be beneficial to lawyers, right? The things that don't need lawyers get taken care of, and the things that bubble up to lawyers are the more complex problems that they're actually better situated and enjoy engaging. All right, I think you're going to have an answer for this based on one of your slides, but it's also a really difficult question. What does a just world look like to you?
So a just world could have a lot of lawyers or no lawyers, but it would mean that when communities make decisions about collective norms, and so in a democracy we do that through electing people and they make laws, that the things about life that we've decided are so important that we have a collective stake in how they're ordered, that those things go down in that way within the parameters that we've ordered. And that ordering is accessible to everybody. And it doesn't matter who you are or where you're from or whether you can afford it or not. Everybody is subject to the same order. That doesn't sound very glorious, but.
No, and I think you had a slide that kind of spoke to that, right? Equal norms applied to everyone in a way that's applied equally. So, on the technology front, I don't think your data spoke to this so far, and I don't think your comment earlier spoke to this. So, do you know, and maybe you don't know, but do you know with the millions of transactions, if not tens of millions of transactions on eBay or Amazon or other e-commerce providers, some subset of which have to result in disputes, right? My sense is most of those disputes aren't making it to lawyers, but a lot of them are getting resolved. So I don't know if you have data or if you're aware of other people's data on that. Can you speak a little bit to how, 20 years ago, those legal justice problems didn't exist in that fashion, right? I might have had a dispute with the shoe store or whatever, but I didn't have it in an e-commerce environment where I never saw the person, et cetera. So how has technology or, is that a situation where there's an access to justice problem, or has technology and infrastructure created access to justice for most of those players?
So that is a great question, and it brings up something that I'm surprised y'all haven't brought up yet. So eBay has a largely automated dispute system that's based on learning inductively from lots and lots of disputes that come through about what are the solutions that people seem to think are the fair solutions and that meet the rules that eBay sets. And it has a pretty high success rate after watching millions of these cases come through. But why are they happening in eBay? And this is where lawyers can do things that computers and paralegals can't do. They're happening in eBay because every time you buy something online, you click that little terms and conditions thing that says, I agree to all this stuff, which is pages and pages and pages, usually which includes, I promise never, ever, ever to pursue any dispute with you in law. That's true with your credit card. It's true with all kinds of stuff you buy online. So if I buy a book on Amazon, I give up my legal rights about that purchase. But if I buy a book at the bookstore, I don't give up my legal rights about that purchase. Thinking about whether that's a just legal regime or a good legal regime is something lawyers would be really good at. And thinking about how to change it, whether through litigation, whether through mobilization, whether through legislation, is something that lawyers would be really good at doing. I mean, there are big substantive issues in the law. The way that I've defined access to justice is the law is, and we follow it. But the law, of course, isn't always just either. And so lawyers are uniquely placed to be able to identify those injustices and act on them with skills and tools that other actors in society don't have.
So that's our last question. do you have any final words of wisdom to share with our audience?
No, I just want to say it's been a privilege to meet with you today and to learn about, I think, the really unique and very powerful mission of this law school. And that's been inspiring and encouraging, and so thank you.
So thank you all. I especially want to thank the people who asked questions. Only a couple of the great questions were mine. Many of the rest were from you, so thank you.